Good afternoon. I wanted to talk briefly about the difference between uh, mediation, arbitration, and litigation in terms of resolving disputes. A lot of times these terms are thrown around and people think that they know what they are, but they aren't necessarily sure, and they can be confused and conflated. So I've kind of created a quick checklist for these things. So let me pull this up. All right. So mediation in the context of resolving disputes is an informal process. That's the main takeaway. What it is it's just you agreeing with the other person to sit down with a neutral third party and try to resolve disputes. Um, that's what it typically is. So if it's just you and the other person talking it out, that's fine too. You can do that. But sometimes, you can't reach agreement between the two of you, so you need someone else to step in, and that's what mediation would be. So mediation can really be any neutral third person. It could be a mutual friend, acquaintance. Most likely, it's an attorney or former judge or someone with mediation and training experience. It's a private thing, so it's something that you would just arrange with the other person and the mediator. And it's non-binding, meaning you don't have to, whatever happens at the mediation, you don't have to agree on anything unless you want to. So it's just an opportunity to sit down and see if you can resolve your disputes informally. And if you can, great. And sometimes a third person, neutral third party is helpful because they can see things that the parties themselves can't see. It's probably the least expensive of the three options because you're just going to pay the mediator for their time, whether that's an hour, 2 hours, however long it takes to try to come to terms. It's DIY, which is do it yourself. Meaning you don't have to have an attorney or legal representative do it. The parties themselves can do it. And it typically would be resolved in a day or most likely a lot less, just a couple of hours at most. So that's mediation. Let me compare and contrast that with the term arbitration. So the difference, there are several differences. Number one, it's a little bit more of a formal process. So what do I mean by that? It's a neutral third party that's the arbitrator. Sometimes it's several different arbitrators. But what they do is they act like a judge of a case, even though they're not judges. They're not elected officials. Again, it's just a person, a private third party that you would hire. There's arbitration companies you can use. The most common one in the construction industry here in Georgia is CAA, Construction Arbitration Associates. But there's also AAA, which is kind of nationwide, worldwide even. And so what they'll do is they appoint an arbitrator to act as essentially the judge or the referee of the case. And so it's more formal in the sense that you do have to present evidence of your case. You do have to present your documents, your contract, your witnesses, whatever you would need to prove your case, you would have to provide that to the arbitrator. It's also private, which means that it's not a public proceeding. You wouldn't be able to find a record of it online or with the court of clerk's office. It's binding. Meaning that whatever the arbitrator decides is the final word on the case. So it's not like a mediation in which you only resolve it if you come to terms on some agreement. An arbitration is decided for you by the arbitrator. And it's more expensive. So you have to pay an upfront filing fee for the arbitration. It can range anywhere from $500 upwards, depending on the size of the claim. And then there's other costs associated with the arbitration. So typically any time there's a hearing on the case, if the arbitrator wants to have a status conference, there may be a fee for that. If you want to continue the case, there may be a fee for that. So the fees can add up. And these are the arbitrator's fees, the arbitration fees, not necessarily legal representatives fees. But it's also DIY. You can do it yourself. Parties can represent themselves in arbitration. You don't need a lawyer to do so. And the whole process was probably several months between the time of filing your arbitration demand and actually having the arbitration hearing. So it's a little more complicated, more convoluted than mediation. But again, there's some key differences. Now let's look at the third option, and that is going to a traditional court. So there are a lot of differences with this, plenty of differences. Court is the most formal proceeding. And by that I mean there are very specific rules you've got to follow for how to file stuff, for when hearings occur, for the presentation of evidence at a hearing or a trial. It's just a very formal process. It's public, meaning once you file a lawsuit, anyone can discover the results of that lawsuit. So if your company's never had a dispute before and you've kept your name out of any court records, then your name, the company name, would be public in that case. If there's any sort of adverse judgment against you or your company, that would be public. It's also binding, meaning whatever the judge or the jury decides would be binding upon the parties. And it's probably the most expensive. And the reason being is you see the time frame, 1 to 2 years in most cases. That's what really drives the cost, is the length of the proceedings. So you between the time of filing the case, the courts are just so backlogged, especially now with COVID. It's just going to take a long time for the case to trickle through. And so you're not going to get any sort of resolution on this for 1 to 2 years. Now, it's different if you have a small claims case. And small claims in Georgia is any claim that's under $15,000. So there's kind of an exception for that, in that in a small claims case, let's say you're owed $7,000. You can file that in small claims court. It's a lot less of a filing fee, probably about $100. And you can actually do it yourself. A company can do it themselves. An individual can do it themselves. You can represent yourself in a small claims court in Georgia. And so the resolution there would probably be more along the lines of an arbitration. It would probably be resolved in a few months, maybe up to 6 months. But it wouldn't drag on for years, or it shouldn't. So those are the main differences, between mediation, arbitration, and court. For a lot of the reasons I articulated, in the construction industry, a lot of times we prefer arbitration. Well, and mediation is a first step, but if you can't resolve it, then arbitration. And there are several reasons for that. The main one I haven't talked about is that in arbitration, you're going to typically get an arbitrator that's familiar with the construction industry. So familiar with these types of claims. A lot of times they're former contractors themselves. A lot of times they're not lawyers. So they may be actually working contractors or retired contractors. They may have some legal training. They may have, litigated cases in the construction field. But you're going to get someone that's knowledgeable about the industry. And the advantage to that is that, unlike a judge they may hear one construction case every few years. They're going to know a lot more. They don't need to be explained a lot of the facts. So they'll get things a little bit more quickly. You don't have to present, as much evidence as you may in a court for the arbitrator to understand what's going on. And they'll also be familiar with a lot of the defenses that an owner may raise to the construction cases. So the familiarity with the subject matter is pretty important. And for that reason, and considering the cost, it's a little bit more cost effective. That's why in the construction industry we tend to prefer arbitration as opposed to resolving things in the court. So that's just a little bit about the different types of dispute resolution mechanisms available for construction cases. I hope that was helpful in articulating the process, but feel free to contact us at downslawllc.com for more information.